continuing discussion for looking at next year's budget, but really want to dig a little bit deeper into the how pre-charge has been used, how it's being used, and we're going to hear from a number of different individuals who are using that, and then we're going to be hearing from folks telling us what kind of funding needs there are. But we're going to be the schedule agenda. We're going to be kind of mixing it up a little bit as far as the who's going to go where because of some time requirements. But we are going to start with a quick review of Act 180, establishing the pre-charge program with Legislative Council. Then we're going to go to Judge Tebow, and we'll figure it out from there as far as people's availability. So over to you, Ben.
Sounds good. Thank you, Mr. Chair. For the record, Ben Nowogroski from the Office of Legislative Counsel. I will be doing a very brief overview of the 58-page Act 180 of 2024. So if you see before you, there is a 1 1/4 page handout, just kind of summarizing what Act 180 does and does not do. So very high level, this majority of this act lives in Title III, Sections 163 and 164, which are the juvenile diversion and adult diversion statutes within the purview of the Attorney General's office. So just to sort of orient the committee about where in the law we're talking, outside of some organizational reshuffling, what Act 180 did writ large is codifies pre-charge diversion for both juveniles and adults. And it retains the current post-charge diversion programs and designates them as such, because before it was just diversion, but now it's pre-charge and post-charge. So the initial question, what is pre-charge diversion? So pre-charge diversion is defined in 162A sub 4 as a referral of an individual to a community-based restorative justice provider by a law enforcement officer or prosecutor after the referring officer or prosecutor has determined that probable cause exists that the individual has committed a criminal offense, and before the individual is criminally charged with the offense or before a petition is filed in family court. Pre-charge diversion shall not be construed to include a community referral. And a community referral is a referral, essentially a direct referral to an individual to a community-based restorative justice provider that does not involve criminal offenses or delinquency for which probable cause exists. Within that, you may have a question about what is probable cause. So probable cause, there's reasonable suspicion and then probable cause. Probable cause exists when the facts and circumstances known to an officer are sufficient to lead a reasonable person to believe that a crime was committed and that the suspect committed it. So that is really the threshold to bring a criminal charge. And so that's sort of the tipping point, if you will, in pre-charge, where there's enough evidence that a crime has committed, but for whatever reason, and I'll get into what those reasons are, it's going to be referred out to community justice or restorative justice provider. So the way that this works is that the Attorney General office will administer the pre-charge program as it currently does for post-charge diversion. And it does not affect other referrals from law enforcement. It shifts the grant authority for these community justice providers from the current structure under the Department of Corrections to the auspices of the Attorney General. It, from a logical perspective, sort of makes sense that DOC deals with people after they've been tried and sentenced, usually. The Attorney General and prosecutors deals with people prior to that. So that is one of the explanations as to why the grant authority is shifting to the Attorney General's office. A prerequisite within that funding structure to receive AGO funding is the adoption of a pre-charge diversion policy by the state's attorney. And also the AGO can designate a single municipality or a single entity within a county to receive funds, but it may also permit that designated entity to subgrant or subcontract with other providers within the county. And as I mentioned before, state's attorneys are required to adopt a pre-charge policy. However, they retain final discretion over the people and the crimes that are contained in the policy. However, there are certain requirements for documentation. They have to establish eligibility requirements, which type of crimes can be included, and those policies have to be publicly posted on the Department of State's Attorneys and Sheriff's website. The legislation also clarifies the rights and responsibilities of diversion participants and victims. It requires that a manual be created to be used by both providers and others who are involved to ensure that the requirements of the program are adhered to, how to execute them. Participants are offered a public defender at no cost upon consultation about pre-charge diversion. And then victims are notified of their role in the diversion process and the right to certain information about the participant when they engage in the process. It also creates a record deletion, which is akin to expungement for pre-charge diversion. So all records are deleted after 2 years elapsed from the completion of successful completion of diversion. And then, but there is a limitation that law enforcement and prosecutors are permitted to retain ValCore database information and other similar private data for criminal justice purposes. It also codifies data collection requirements from providers to be reported annually by the Attorney General's office in consultation with other agencies. So things about the volume of referrals, success rates, demographic information when available, things of that nature. And then it creates a working group to examine the creation of a post-adjudication reparative program. So this would be after sentencing, a work group designed to provide access to appropriate community-based providers for people who've been sentenced to reparative boards or to probation. So it's not all sentenced individuals, it would just be those within those two categories. And then it would also establish a stable and reliable funding structure to support providers. There are sort of certain check-ins that were established. The beginning of this year, there could be an update available if requested over the summer to Justice Oversight, and the report will be due at the end of this year. And then finally, the Attorney General's office is charged with collaborating with providers and state's attorneys to develop a plan to streamline the administration and provision of the programs. One of the objectives of this is to stabilize funding among other processes that are attendant to pre-charge diversion. And then finally, the Attorney General office is charged with collaborating with police organizations and the Office of Racial Equity to explore the funding of community referrals, which are not really touched on in this law. If you were to flip over, what Act 180 does not do is that it does not prevent justice providers from accepting community or school referrals or post-charge referrals other than what is in current law. And then this bill does not create a stable funding source long-term. It puts in place initiatives to examine what those funding streams could be in collaboration with all the other stakeholders, but it does not specify dollar amounts and does not source funds from any particular location. And again, that shift from DOC to the Attorney General's office is necessary because of sort of that logical aspect that I discussed earlier. But last year, DOC had indicated that they would no longer fund these grants, and my understanding is that they are not funding those grants anymore. And so therefore, there needed to be a home to issue those grants. So any questions in that very brief overview?
It's a small bill.
It did a few things. All right, great. Thank you, Ben. And you're around certainly if we do have questions. And
It's right there.
Yep.
Think you could be a little closer?
You don't want me closer. Yeah.
So we will welcome back Roy Tebow, who used to haunt this committee room quite often before he stepped into his new position. So thank you so much for being here, Judge. And if you could identify yourself for the record and proceed.
All right, good afternoon. I'm Roy Tebow. I'm a Superior Court judge. My current assignment is in the Criminal Division in Orleans County. So first, I'll say thank you very much for inviting me back. It's always fun to come back in a new role and to see some old friends in the room. I also greatly appreciate, Mr. Chair, you accommodating my schedule. The wheels of justice are always turning up here in the the Great North, and I have some hearings later today. So thank you for letting me jump the line a bit. With that said, starting on behalf of Judiciary is maybe a bit misplaced when we're talking about pre-charge, which presupposes that we're addressing cases that never come before a judicial officer or into the court system. So the main thing I wanted to just address briefly today, and then allow any questions you or the committee members have, is to just note what the potential savings of time and effort are within the judicial system. Certainly the watchword of the judiciary and of court operations for the last few years has been backlog. And from a fundamental sense, I'm sure everyone appreciates that if you have an equal number of cases going out of the system and an equal number coming in, you're never going to make much headway. So the tracking things and moving things along requires more cases to be exiting the system than entering. So from that standpoint, while the judiciary views this completely as a policy issue about how local counties and prosecutors utilize or do not utilize pre-charge programs, there are some benefits to the system overall, which in summation would allow for the court system to focus on cases that must be in court. So while it's a policy decision, certainly the state's attorney or other stakeholders can look at what the preferred mechanism of accountability is. And a pre-charge referral to diversion or an alternate justice program may do that because restitution or reparative process may make a victim whole and may provide the appropriate degree of accountability. So while we don't have any stake in those decisions, what is important to note is that when a case is filed, even a case that goes the traditional track of being post-charge referral to diversion, that requires a centralized intake of a case, creation of a docket, a local judicial assistant to handle the matter, refer it to a judge for probable cause, set it on a calendar, get appropriate hearing notices generated, and do any number of things that are administrative. In one individual case doesn't necessarily take a lot of time, but in aggregate over the course of a year, those cases do add up. With that said, assuming someone successfully completes a post-charge diversion program, there's more administrative hurdle where external partners file a notice of completion, court then dockets the dismissal, and then down the road, 2 years later, there's an order generated, and again, administrative and judge time spent on sealing a matter, and eventually expungement is typically granted in those cases. So the lifespan of a singular diversion case can spread out over years based upon some of the mandated things that happen upon successful completion. So certainly, in that sense, it can be a great benefit in terms of addressing backlog when there are fewer cases coming in, if the appropriate authority, whether law enforcement or a state's attorney, determine that the interest of justice can be served without going directly to the court process. One benefit, of course, is that does still allow if someone is unsuccessful to resume a prosecution and pursue a traditional outcome or track. So with that said, this is a bit out of order, probably not a lot from the judicial standpoint to share, but I'd be more than happy to answer any questions the committee has.
Questions from the committee? So when you mentioned long term for the diversion, you're referring specifically to court diversion and some of the additional procedures or hurdles in that path?
Precisely. So understanding that some of these cases that are considered for pre-charge might otherwise be filed as diversion cases. And again, while those are largely administrative and don't require a lot of necessarily deep thinking or thought or direct decisions, it still does contribute to the administrative time that our judicial assistants and judges do devote. And again, aggregating that over time, if it's, let's say 100 cases per year, that does add up to be a quantifiable and somewhat significant amount of time. So as I mentioned before, when looking at backlog, any means by which appropriate public safety stakeholders can view appropriate dispositions outside of the judicial system tends to benefit and allow that system to focus on the most critical cases.
Karen.
Yes, hi, Judge Tebow. I can't remember which court are you located at?
I'm currently in the Orleans Criminal Division.
Okay, great. And so I'm trying to, and I think we probably have some other folks that are going to speak to it, but is there pre-charge there now?
There is, and I believe State's Attorney Leva and Ms. Proya from NECA could probably speak to that a lot more in depth. And I'll have to admit that necessarily when it's pre-charge, I don't actually see it or anyone in the staff here. So that said, I think that the office here, both really all the stakeholders in this county in particular have been really, I think, mindful of the backlog and finding more creative ways than perhaps in the past to dispose of cases or reach accountability without the traditional track being used.
Okay, so you see a benefit to it. And I think part of what we're here today is going to be hearing about the funding request for pre-charge diversion. So trying to understand why is this funding needed, or what would the impact be if this program wasn't funded? And it sounds like, from your perspective, there would be a direct impact on judiciary.
Certainly, I think that it assists, and it's difficult always to quantify. And one thing I'd encourage the committee or others, really, whenever looking at something in the justice system, is quantifiable data. In my former role as a state's attorney, I knew sometimes it was difficult to capture some of those touch points that happened without a charging decision or a case being filed, because it's just more difficult to track. I know in some jurisdictions, law enforcement are by policy allowed to make direct referrals to community justice centers and deal with lower level crime at a level that doesn't directly call for court intervention. Capturing that data is probably increasingly important as you folks make funding decisions going forward.
Great, thank you. And that is a big piece of this. I know it's data collection as well. So thanks.
Any other questions? No, we are all set. Thank you, and good luck in clearing some more cases at your hearings this afternoon.
We'll try. Thank you very much. Wonderful to see all of you.
All right, nice meeting you again. So we'll go to Franza next. Thank you for being here. If you could identify yourself for the record and proceed. Thank you.
Yes, thank you so much. So my name is Farzana Leva. I'm the Orleans County State's Attorney. And just to compliment Judge Tebow there, he has been an absolute asset to this county, and he has essentially reduced the backlog drastically. So we're super thankful for him, and I just thought I should let you guys know that he is doing a phenomenal job here in Orleans County. I do have an updated policy for pre-charge diversion that I will be sending over to Tim. I have listed, I really went through several different types of cases that I see coming through with first-time offenders. And some of these include like petty larcenies and retail thefts, DLS cases where they could actually gain from pre-charge diversion. So I have at least 10 offenses at this point in time, which I also provided, I think, over a month ago to Alexis from NECA. And so in terms of pre-charge diversion, I think it's an absolute valuable opportunity to redirect eligible individuals away from the traditional criminal justice system before charges are filed. And I think success really depends on a careful implementation by case evaluation and a robust data collection. So pre-charge is not going to be suitable for every case, and certain offenses, particularly those involving repeat offenders or serious crimes, may require the traditional prosecution. But so from the state's attorney's perspective, or my perspective, I think those must be assessed individually to determine the appropriate course of action. In terms of, I think pre-charge diversion is going to assist individuals with the tools that they need. Specifically in this county, what I see is we have individuals who have, and they don't have stable housing. Drugs is a huge issue. We have mental health crisis in this county. And so I think getting funding to increase the resources in this county is going to be very, very helpful. And I think Alexis might be able to also assist with this. We actually have the least amount of resources in the state, I think, personally, because even listening to Judge Tebow during hearings of what Washington County has compared to what we have in Orleans County, it's not on an even playing field. And I think that's very unfair to our community. And so I'm digressing, but I just really want to say that, we need accurate and consistent data collection by the CJC and diversion office. I think that's going to be really essential with the pre-charge program. I think what the data collection is going to do is really, it's going to have a meaningful evaluation of the program's impact, how many cases have successfully completed, before charges are filed, And I think without that comprehensive data, it's going to be impossible to measure the success or to assess the effectiveness of the diversion referrals. And I think it definitely would free up a lot of prosecution resources. It would give us the opportunity as prosecutors to focus on more serious crimes, on repeat offenders. And so I think having a strict timeline, best practices, needs to be established as well to ensure efficiency. And so, I think in order for there to be a success with the pre-charge diversion program, data collection is going to be really important because it's going to demonstrate the program's effectiveness, identify areas of improvement, justify continued investment, and also help determine whether diversion is alleviating the case backlogs. I have sent several cases to diversion since my time here, and honestly, some of those individuals I've never seen come back again. And so I think that is really important to sort of give these individuals the tools and the chance at success. And again, I will reiterate that I see a lot of our criminal behaviors from even young adults stemming from the current situation that we're facing: mental health crisis, drug crisis, housing. And honestly, like, we cannot get individuals to come to this area, even to work. We don't even have housing that allows for people to come to this area. So again, I digress, but just coming back to the pre-charge diversion, I think it would be Orleans County, I know, would the word I'm trying to use is benefit from this, and I am all for it. And Alexis and I have a really good relationship, and I'm sure she could, go further into how we deal with some of the cases here. But I'm happy to take any questions from you.
Great. Thank you very much for your testimony. Angela.
Hi there. Thank you, Farzana, for being here. I just wanted to make sure I understand what you mean when you said that Orleans County doesn't have the same resources as other counties. Are you talking about community resources, state's attorney office resources, judiciary resources?
I mean, I would defer to Tim about our state's attorney's resources, but community resources.
Okay.
Yes.
Okay, thank you.
Other questions? I don't see any other questions. I think you really covered it very well, so I really appreciate that. And so, Tim, I think we'll kind of go back to you later, and we'll go to Alexis next to hear from her if she's available there. Yes, thank you for being here remotely as well.
Yes, thank you for having me. My name is Alexis Proya. I am the Orleans County Court Diversion Director, and we're really fortunate that our diversion program is embedded with Northeast Kingdom Community Action. That gives us an opportunity to meet a lot of individual needs because we offer a lot of services. Since data collection was mentioned a lot, I just wanted to start there. I have the opportunity to oversee programs within the AGO, DCF, and DOC. And I will say the Attorney General's office, our data is so useful, and I just want to speak highly of the amount of data that we're able to use and then receive back to be able to better our programs. We utilize customer satisfaction surveys, and also we're collecting data from the moment that we receive a referral to the end. And it's been very helpful to measure success and track success of our cases. I will say that pre-charge diversion is effective for low-level adults and youth in some counties, and I think that's part of the conversation that Farzan and I have been having. Like, law enforcement officers would be able to refer cases quickly to us, allowing us to connect with victims and our participants/offenders promptly. And with doing that, we're able to start the restorative process in a really timely manner. As you heard Judge Tebow say, having low risk cases bypass the court system really helps with the backlog. It also enables us to address underlying issues swiftly and begin the process really quick. I like to point out that what success means in a restorative agreement. So victims, they feel empowered. They're able to start the healing process right away. They feel heard, respected, and their needs are addressed. Victims achieve a sense of closure and which reduces their fear of re-victimization. The offenders themselves, we call them participants, take responsibility for their actions, and in meeting with, community representatives and creating an agreement to restore the harm, they're better able to understand the impacts that they have had on the victim, the community at large, and they're more likely to make positive changes and less likely to reoffend, reducing recidivism rates. I would like to share a story. Recently, we worked with an 18-year-old young man who was charged with negligent operation for doing donuts in an empty shopping plaza. His arraignment had been scheduled out for like a month and a half out because we were able to do a youth assessment screening. They decided to send them back to us pre-charge. So what that did was we were able to complete the process in about a month, which was saved time. We were able to complete it before his arraignment even happened. And so what this was able to do for this young person is it prevented an impact on his career, because at the time he was going through a CDL program and he was afraid that it would mess up his career prospects because it went through pre-charge, there was no impact on his current future. His future career, sorry. That's where I would like to end and open up for conversations, if that's okay.
Great. No, that's great. Questions for Alexis? Yeah, Karen.
Yes, thanks, Alexis, for being here. Again, I'm trying to frame this for us in the budget context of it, because we're going to hear about the budget needs for this.
Sure.
So how is this program funded for you, or what are you hoping the funding will be? Because if we don't fund it, what's the impact going to be?
Absolutely. So currently it is funded by DOC, and as you've heard, those monies have shifted moving forward. So if it is not funded, we will not be able to offer the service. That's the impact.
Thank you.
Just a follow-up question. I mean, how do you, without having collected the data, which would be collected under this pre-charge program, are you able to tell us about how many pre-charge cases you have and what you would anticipate as far as capacity? Would you be able to expand your capacity for additional pre-charge cases under this program?
So we will be able to expand our capacity. Currently, we're receiving pre-charge for young, like youth 18 and younger. And what Farzana and I have been working on is an agreement to extend that to adults that are low risk as well. So we will be able to expand. Over the past 6 months, we've had 10 young people referred to our program. 4 completed successfully, 4 completed successfully, 4 are currently still continuing with the program, and 1 chose to go to court to plead their case.
Oh, I appreciate that. Other questions for Alexis? You sure, Angela?
Yeah.
Okay. Thank you so much for your time, and thank you as well, Farzana. I really appreciate. It's good getting perspective from a different part of the state as well than we often don't get up there nearly enough. So I really appreciate that. So Coach, before you go, I think that Christy has a question.
Yes. Thank you for your presentation. Uh, the question is, do you receive any funding from DOJ, the Department of Justice, or any other federal programs?
Alexis, did you hear that question? I think it was directed to you.
My apologies. Can you repeat the question? I didn't realize it was coming to me.
No,
Sorry.
that's quite all right. Go ahead, Coach.
Um, I was just curious if you're receiving any funding, support funding from the Department of Justice in the work that you're doing as well.
My office currently does not receive funding directly from the Department of Justice. Our department is funded by the Attorney General's office, the State Department of Corrections, DOC, and Department of Children and Families.
But you led that with directly. So indirectly, do you?
I said that because I'm not sure if those three that I mentioned receive funds.
Okay.
Sorry.
Okay. That I was just checking to see, just concerned, about our federal situation,
Yes.
with funding. So that it's kind of a hidden indicator that things could be a little tenuous. So I wasn't sure if you were critically aware or not. But thank you.
We have a bigger impact within our agency. My department, thankfully, but the greater Northeast Kingdom Community Action that serves our most vulnerable humans. Yeah. So
But thank you for your great work.
thank you very much.
Yeah, thank you very much as well.
And thank you so much. I appreciate it. I've got to go to court tonight.
Yes, good luck and get some of those cases cleared.
Yes, definitely. Thank you so much.
Appreciate your efforts.
Okay,
all right,
bye-bye.
thanks a lot. So we'll go to Chief Burke, interim Chief Burke. We'll have to get used to that, I guess. So congratulations or condolences on your newly accepted position. I'm glad that we have you at least well into March. So thank you for being here.
Well, it's always my pleasure to be before this committee. Thank you, Chair Lalonde. I'll tell you that someone is going to get the best police chief's job in the state of Vermont if they can land this South Burlington job. And I'm looking forward to the leadership challenges that Burlington presents. I do have one slide, if I can share my screen, that might be helpful.
Yep. Nate's getting you right now to co-host you.
Okay.
Should be all set.
Right on. Thank you. And you can still hear me and you can see the slide?
Yes.
All right, great. Thanks for having me in. I think the table setting that was done by the prior witnesses was absolutely perfect. So I can talk to you about how we actually operationalize this here in South Burlington. Super unique situation here in the city of South Burlington, where the Community Justice Center is actually embedded with the police department. So our interface with that program is a simple matter of policy. As you're probably aware, Chittenden County's had a long-standing commitment to using restorative justice and resolving crime and disorder. I believe it's been under the last 3 state attorneys that we've had memorandum of understanding, which permit us to do direct referrals. So the slide here before you is just South Burlington data from fiscal years 19 through 24, just to kind of put a dollar figure on this. In today dollars, so FY25 dollars, our CJC runs on a DOC grant to do pre-charge work and restorative probation work that amounts to just about $150,000. Obviously, in the earlier fiscal years, those amounts were less. So our CJC is also supported through a Crime Center Victims Grant, VOCA grant, but that enables our parallel justice work, which is reaching out to crime victims to see how we can assist them, how our CJC can assist them, as well as to give just an opportunity or a stage for the crime victim to have voice in what they experienced. And that really, in sum and substance, is the funding sources for our CJC. And we have 2 full-time staff members. In terms of our dedicated work on restorative justice, what you see here before you is a body of 600 cases that were referred across the fiscal years mentioned. And the bottom bar shows that the number of completed contracts, meaning that our CJC professionals were able to take the case in. We have a policy, as mentioned, it outlines 14 specific misdemeanors that are always eligible. Really, the barrier is whether or not the responsible party or the defendant in these cases wants to engage in the process or not. And that's a determination that's made by the officer. Once the referral is made to the CJC under the grant terms with DOC, they've got 5 days to reach out and make connection with the responsible party. And again, 386 of those people fully engaged in the process and completed their contract and adjudicated a probable cause level crime that never touched the criminal legal system on the backside. This data is inclusive of juveniles and adults. There is the next greatest bar is the no contact bar. And this is just what it is, people that we couldn't get in touch with. I will tell you that this data is a little skewed on the high side because we did do a policy shift in 2023, trying to take officer discretion out of it. And we were going with referrals on all crime types. But we realized that we had a recidivist population that I spoke about in our overview conversation a few weeks ago that we're never going to engage in this process to begin with. So this 179 number is a little outsized if you were to look at year to year trend bar, if you will. We had 7 folks that just didn't show up after the center was able to make contact with them. 11 that failed to complete the tenets of their contract. And I spoke about this point in earlier testimony as well. This is meaningful work on the part of the responsible individual. And, not everyone is up to doing that work. And then 17 individuals fell into this abyss that we categorized as the cases went unresolved. So they were not adjudicated in our system. I will say that as a backstop to the cases that are not completions, those cases do go to our state attorney's office, and our current state attorney will have staff look at least at the merits of the case and determine whether or not it should be filed, or if this defendant has other dockets and they're not at least in a summary fashion outright dismissed. But I think the big takeaway for the committee is, I'm really short dollars. We're doing meaningful work that gives crime victims voice, represents the community and the community's value in resolving crime and disorder, has people actively taking responsibility for their criminal impulsions, and not touching the criminal legal system whatsoever. And 600 cases may not seem like a huge number, but we're just one police department. Granted, we're the second largest police department, but only one. And I just can't say enough about what I believe in this work, especially in terms of the number of folks that we do see in the, say the 15 to 20 year of age, getting involved with a very minor criminal offense, and then being able to resolve it in this way where we typically won't see them again, and they don't have to wrestle with a criminal record when they're trying to apply to college or get some type of professional licensure or rent an apartment, or, you name the scenario. So I really think that this work is important and something that I think about, and I'll just say for you to consider is that really to adjudicate criminal justice is a state responsibility. Under restorative justice legislation, municipalities were empowered to do this work. Many of us are doing it at a very high level, and it seems only logical that the state continue to fund these programs. And with that, I will try to revert my screen, and I'll send this slide to Nate, and happy to answer any questions.
Great, thank you. Questions? So I guess I'll ask one question as far as if you could talk about the funding challenges that you're facing as far as with DOC changing the way that they're doing the funding and the like.
So sure, great question. Thank you. So obviously our budget for the municipality needed to be before council in January. DOC at that time had already intimated that there was going to be zero pre-charge dollars allotted in FY26. It was $150,000 hole. So we shored that up about half as much with municipal funds. And there are some reserve funds from the program's operation, the historical operational recapture. We know that we can run our program through fiscal year 26, but beyond that, if there's not state funding, I don't see how we continue this work.
Get that. Any other questions? Yeah, Andrew.
Hi, Chief Burke. I don't quite know how to ask this question, so I definitely don't know how you can answer it, but I'm going to try anyway. I'm just thinking about the slide that you shared, and I think was it 386 completed contracts. And we talk so much about public safety and in the sense of feeling safe and you know that the importance of that feeling in the community. Do you have any sense of how the resolution of those cases in what you didn't mention time, you know, disposition times in the RJ context, but it's probably safe to say that it's significantly shorter than criminal context.
Yes, so Judge Thibault testified and said that it takes years potentially. And the criminal legal system, we're talking months in restorative justice. And I'll tell you, like, in terms of like how people feel about their safety, you know, that really gets back to the whole recidivism thing that we talked about a few weeks ago, where you have defendants stepping up, taking responsibility for their actions, engaging in this process. Those aren't the people that we're doing constant radio runs or, you know, responding to calls for service and arresting. This process is not viable for people that are service treatment resistant or think that they're innocent and want, you know, the traditional avenue to advocate for their innocence. This is for, you know, a decent sized catchment of criminal behavior of people that want to really just take responsibility, learn about the negative implications of their decisions and move forward.
Right. And not to conflate two conversations that we're having at the same time, but it's striking to me how similar what you just said is to a lot of what we're hearing about the controversy regarding raise the age, and that there is this population for whom this particular solution is not a viable option. That doesn't take away the fact that it is a viable option for a great many people. And I think that this is a good illustration of that fact, and the two are not unrelated. So I am going to conflate them.
I guess I would challenge you just a little because, you know,
because I'm contradicting something you've said before.
But I guess then I just want to be clear that systems where people are willing to take responsibility for their behavior are effective.
Yeah.
Putting a blanket policy out that just because you're a certain age makes you eligible for something is flawed policy in that regard, because you have people that are highly resistant to changing their behavior. There's you know, from a practitioner standpoint, I'm not an academic, but from a practitioner standpoint, these models don't work together, but they are all in the ecosystem that's going on. So I have this work in the restorative justice world that goes on the second floor of my building. And then simultaneously, I could have a DCF worker with some type of juvenile probation delinquency issue sitting in my lobby for 2 days because they have nowhere to go. So those are related, but not directly in relation. I guess they're not meshing like gears in my mind at all times.
No, and I agree. I wasn't. It's really more of a philosophical point that I'm trying to make. Apparently not very well, but we can have that conversation another time.
All right, fair enough. Ian.
Bringing it back to the budget.
I mean, I could go there too.
I'm just joking. I'm curious,
I was supposed to say that.
Yeah, exactly.
So, yeah.
I'm curious, and this may not be a question for Chief, it might be a question for Martin, I'm not sure.
Okay.
Have we ever tried to have a discussion in this committee around like what the cost of a average criminal case is? When it comes to like the staff for the court, the judge, the prosecutor, defense attorney, like all those costs on the court system on like an average basis.
Right. So I don't know if Chief Burke can answer that, but we're having Robin Joy in tomorrow. They did do a study on cost, not across the board, but they took a type of case and they looked at how much does it cost to go through diversion, how much would it cost to go through court. So we can have her talk about that and other data issues tomorrow.
Because just to bring it back to this testimony, I think like the over 380 cases that were pre-charge diversion, if you were to take that and whatever that number is,
right,
and multiply, yeah, it would probably be a lot more cost on the state than.
Right.
Yeah.
Right. It's, I think we've been hearing testimony consistently last couple of years that this is a less costly, more effective path for the rate cases. And so I think that we've heard that again from the witnesses so far this morning as well. So thank you so much, Chief, and we'll try to get you in here at least another half dozen times before you get overly swamped in resolving all issues in Burlington.
Wish me luck.
Yes, yes, our good thoughts go with you. So thank you.
Thank you so much. Take care.
All right. So why don't we take, let's see, we still have Heather and Tim a little bit further and then Willa. So why don't we take a 5-minute break and then we'll finish.